So we're live now, Kevin.
Okay.
And we'll, just for everybody's benefit, we'll wait a minute or two just to allow other viewers to join up with us now that we've started the broadcast, and begin the presentation in probably 2 minutes. All right, so we'll go ahead and get started now. I think Keith Bergeld and I are really excited today to have Kevin Jakel, who is the CEO of Unified Patents, present to the OIN community. Kevin built a pioneering business that helps combat the risks from patent trolls for non-practicing entities. And we're really excited and appreciate your time today, Kevin. One thing, just for everybody who's joined us via the Google Hangout, if you have any questions to ask Kevin, you can send those questions in to info@openinventionnetwork.com, and I'll go ahead and read those questions to Kevin live. You can also, if you're a Google Plus user, you can go on the Google Events page and post a question on that page, or we've activated the Q&A module for the Hangout, so you'll be able to use the module to ask questions. So with that, Kevin, I'll turn it over to you and the presentation.
All right, well, thank you very much. I hope everyone can hear me. I'll do a quick introduction. I do have some slide materials, and I'll walk through those. I'd like to reiterate that if anyone does have questions while I'm going through the material or talking, please do not hesitate to interrupt and put your questions in. And Edward, feel free to interrupt me if you do get something. I think it makes for a lot more dynamic and interesting conversation to have you ask questions and for me to answer them rather than me be a talking head this whole time. So please go ahead and interrupt. Let's see, maybe a little background on myself. I used to be a patent examiner a long time ago. Then I moved on and was a patent prosecutor for some firms in Washington, D.C. Did that for a little bit before moving on to litigation. I was a litigator for many years, traveling around the country before going in-house, at which point I was head of IP litigation for Intuit. And at Intuit, we faced a NPE problem. In fact, the vast majority of the IP litigation that Intuit faced came from non-practicing entities, or NPEs, and we, I think those are often referred to as kind of patent trolls. But companies that didn't do anything but bought patents and enforced it against companies. I wanted to find a solution while at Intuit that did more than just simply settle or fight. Basically, those are the only two options if you're approached by an NPE. And I personally wanted to see if there was a way for an entity to make companies less likely to get sued again and again and again and again. And so that, with that goal in mind, I actually left Intuit and started Unified Patents. And its goal is to basically deter NPE activity or patent trolls from reinvesting in technology areas over and over and over again. We started out in cloud storage. Very fortunate to have a group of companies support the effort to get launched in the cloud storage space. And in doing so, we ultimately have been working in the cloud storage area for about 3 years now. And so ultimately, our goal there is to deter NPEs from coming back. So with that, I guess, overall introduction, I'm going to jump into some slides. Like I said, if anyone has questions, please do not hesitate to ask. And I'm going to share my screen. And Edward, is it showing correctly?
Kevin, yes, that looks great. Thanks.
All right. So, like I said, we are an entity which deters. That's really the goal of unified patents, is to create a deterrence. We are a membership organization. Companies join for the company, and we then go on behalf of them to do deterrence work to essentially make sure that NPEs do not have successful monetization campaigns against the technology areas that we're protecting. So some of the key things that are involved in our membership and what we do, as basically a platform, we have a commitment that we never pay NPEs anything. There are other solutions out there that do have a model in which they will buy patents from NPEs, or alternatively, they will pay NPEs money in order to license those patents for their membership. I think while that can save money in some situations, Unified's approach to this is that doing so incentivizes those NPEs to reinvest in the technology area, buy more patents, and sue more companies all over again. In fact, there are hotspots of litigation and NPE activity around technology areas where NPEs do take their profits, they do reinvest them, and they do sue companies over and over and over again on the same technologies. So that's one of the big pieces of creating the deterrence, is making sure that there's a model from day one that never pays NPEs anything. Our second big goal, obviously, is just to reduce the cost of litigation, so that companies are either, one, sued less often, or two, we produce the kind of leverage against NPEs where they are not going to bring litigation in a space. Settlements we want to happen more quickly, and in some cases, NPEs actually just come directly to us after we have challenged patents, and they settle directly with us. Obviously, the final big piece here is that we want to actually clear out some of the risk that these technology areas represent by actually killing patents and making sure that they are not used against companies and members in the technology areas we are protecting. Essentially, we want to be, the front line, first line of defense when it comes to protecting the technology area from NPE activity. So essentially, why do we exist? In some cases, the unified patents might not actually even be needed. But in the current environment surrounding NPE litigation, we actually, I think, serve a really important role. This slide here, slide 3, it's a subset of the overall litigation. We have lots of NPE data and litigation data, and all be found on our website. We basically, on our blog, have put out a 2015 litigation report. Some of that data is here. I've selected this slide because I think the companies that are on the phone or on this Hangouts here today, most of them would almost entirely fall within what we would consider high tech. We strip out or separate patents that fall into pharma and medical. We strip out patents that are purely mechanical into a category of others, so that we get a group of patents and litigation that is involved in what we would call high tech. So even if you're not a high tech company, if you get sued, say you're a bank and you get sued on your web services, we would definitely consider that high-tech litigation. We think that's important because when you look at what's going on in high-tech, the problem is pretty dramatic. You can see that of the high-tech litigation, 88% of it is brought by NPEs, which is a pretty dramatic percentage. So this is not operating companies using their IP to further their business operations. most of this litigation is NPEs who have purchased patents, and they want to sue companies for a financial gain. So I've included some additional material here because Edward and I were talking before we got on, but a lot of the companies are going to be on the call today are not necessarily going to be massive behemoth companies. It would be small developers, maybe small companies. And so Unified's model includes both an effort to bring in large companies. Large companies definitely participate and they sign up for our services. But what we also have is a solution where we offer membership to small companies. Startups and small companies actually get to participate in Unified Patents for free. So some of the material I'm going to run through in the next few slides, we don't typically present to $30 billion companies, but I've included today because I think it's important to realize that both big companies and small companies share both risk and responsibility for defending their important technology areas. And so here's just a little bit more on some of the problem and why patent trolls present such a risk. Obviously, for those that are trying to get funding, small companies actually really have significant operational risk and funding risk when it comes to dealing with NPEs. VCs and other types of capital really find that patent litigation is a major deterrent for investment. And it turns out that a lot of litigation actually is brought against small companies. So obviously big companies are sued more often over and over and over again. But if you look at the number of unique defendants, over half of those unique defendants actually make under 10 million in revenue. So we are not talking about this problem only being a problem of the big tech companies like Google and Apple and Oracle and others. We are talking about a problem which does affect lots of small companies as well. In fact, there's from Santa Clara University, there was some research done that took a poll of startups to find out how many of them had actually received demand letters, which are basically a request by an NPE in the letter in the form of a letter saying, we believe you infringed the patent and we'd like you to pay us some money, and if you do, we won't sue you. Essentially, that's what a demand letter is. And of startups, they found that about 30% of those had received one, which I think again is a relatively big number. And so the other real problem, I think, is this has an operational risk. Anytime you spend on this as a problem, really decreases your ability to spend money elsewhere. So there's been another study coming out of Rutgers University that showed the 20% decrease in R&D when there was a troll suit involved. So it is a problem, and it does have downstream impacts for both big and small companies. One additional thing is just who's bringing these litigations. So in 2014, and we will have these numbers for 2015 here shortly, but in 2014, if you looked at all the cases that were brought by NPEs, NPEs break down into basically three different categories. There's individuals, people who own patents in their own name, came up with something, and they are suing others to just try and get some financial gain for themselves. There's also a group of small companies. These are companies that did not sell their patents to anyone. They tried to make a run at a legitimate business. The company, failed for whatever reason, and then they wanted to try and monetize the patents that they had received as part of their operating company. But they have not sold the patent. Again, the individuals and small companies are really asserting those patents in their own name. The third category that makes up 85% is interesting because those are companies that do nothing but monetize patents. So these are situations where the original patent owner has sold their patent to an entity, and that entity is then monetizing those patents through litigation or demand letters or licensing activity. And so this is where Unified is primarily focused. Obviously, the other 15% we deal with as well, but ultimately we want to stop the patent assertion entities. Or more importantly, we want to make sure that when they make an investment in buying new patents, that they do so in the technology areas that are not protected by Unified. We want to deter them from coming back to the same place over and over and over again. So with that as kind of background on the problem, talk a little bit about Unified and what we do, and maybe then walk through a case study of cloud storage. I think that's an area that might be of particular interest to those in the OIN community. And then I think we'll have time for maybe some Q&A if anyone has questions. I would reiterate again, if anyone does have questions, please go ahead and ask. So we basically operate on a zone-by-zone basis. The first, as I had mentioned, was cloud storage, the technology area that we got started in. We've been working in that technology area the longest. There's content delivery, electronic payments, wireless, and automotive, all of which are very active zones. We also have zones that are in development, e-retail, imaging, cellular, medical tech, energy. These are technology areas where companies have expressed interest, but that we are still collecting sufficient membership in order to really launch the zone and be active. Obviously, we have a bunch of companies that have publicly participate in our zones. We also have significantly more companies that are, I guess, kind of behind the scenes. They are in the background, and we do this work, and they enjoy the benefits of it, but they don't necessarily want to be out in front themselves. That is actually changing over time. More and more companies actually want not only for us to be a deterrent for the technology area, they want us to be a deterrent specifically for their company themselves. So here is our deterrence model. So this is what we do on behalf of a zone on a recurring basis over and over and over again. Essentially, within a specific zone, we monitor for any NPEs. We basically watch for any activity in your space. This is, this includes transactions that happen between operating companies. So if you have a patent and you want to sell it, and you sell it to another operating company, we will see that activity. And if the patent is sold to another operating company, we do nothing. I mean, we think that is a great thing. Patents are intended to be bought and sold. And in fact, they're intended to be bought and sold by anyone. So if, however, they are sold to an NPE or patent troll, what we would do is then put that patent on the list to be examined. So and that would, I guess we would monitor other areas as well. So obviously patents that transact and change hands, we are watching for. We're also looking for demand letters or activity from any patents that, demand letters that might be sent to you. We want to find out if there's a patent being asserted in our technology area. And then the other, maybe the easiest one for us to track is just to see litigation. And so when we do see a company sued in district court, we would take that as a sign that that patent is being monitored. And if it's owned by an NPE, we would then look to see and move on to step number 2. So we would take all of those patents that we find in a zone that we believe are owned by NPEs, and we would start looking at the validity of those patents and who owns them. So when we find a patent being asserted in the space that is not valid, and it's got great prior art against it, we think that's one of the real problems here, is that too many patents can be asserted, and because of the cost of litigation is so high, companies really can't afford to challenge the validity of the patent. regardless of whether or not they infringe it or not. In many cases, patents should never have been issued in the first place. There are lots of valid patents out there, but our opinion is that when we look at it, there are far more patents that are invalid and should never have been issued in the first place. What we then do is select patents that we believe are invalid and challenge them at the USPTO before what's referred to as the PTAB. PTAB is a board that was created by recent legislation called the AIA, and it allows companies to challenge the validity of patents using what's referred to as an inter-parties review. And so we would then move on to step 3, and Unified challenges the validity of those patents that we think are both invalid and a threat to our zones. We do so efficiently because we're doing so ourselves. Unfortunately, many patents, when used against companies, they're asserted against lots of companies all at once. In some cases, dozens and dozens of companies. Trying to coordinate all of those companies to take action is incredibly difficult, and one of the problems I've personally experienced both as an outside litigator and as an in-house litigator as well. The difficulty of wrangling that many companies into a single action is very difficult. So that's one of the things that I wanted when I left Intuit, was to have a solution that could independently act to take action and do so early, so that monetization campaigns by NPEs don't have a chance to become extremely profitable, don't have a chance to get momentum going. Once they're really been successful, even if you stop them, even if someone stands up and fights in the end and stops them, unfortunately, they more likely than not had an opportunity to be to license many companies in the process, and consequently are probably profitable at that point, even if they do get stopped. So Unified is there to do that. We challenge efficiently, independently, and early. I'll stop for a moment on the independent part, which is one of the things that's really important for our business model, is that we act separate and apart from our membership. So we don't have the ability to tell our members one way or the other if we're going to file or even not file an IPR to challenge the validity of a patent. And that is something that is somewhat required in order for us to do this kind of independent early work. Otherwise, we would be bogged down by all of the entities participating. But ultimately, that activity really comes to the fourth and final step, which is the selection, the monitoring, the analyzing, and ultimately the challenging of patents, is all designed to deter NPEs from buying patents and reinvesting in the same technology area. Or alternatively, I mean, just as often you get copycats where someone is successful in a technology area and a copycat looks at that and says, well, I can find a patent and do the exact same thing. In fact, it seems like NPEs often do look for patents in technology areas where others have been successful, and they do certainly go after specific technology areas that appear to be ripe for NPE activity. And so we want to go through this process over and over and over again to help make sure that NPEs are not reinvesting in the same technology areas again. It is both a immediate approach, meaning that when we challenge patents, obviously we're doing work that we think is of immediate value. But ultimately, the participation in our zone we think is important, because the long-term strategy of deterring that activity is really the goal of Unified in the long run. We want to save companies money, we want to do great work, but the goal here is to deter NPEs from suing companies in our zones. We don't want them reinvesting in that technology area over and over and over again. So maybe just a few highlights of what we've done and what we've accomplished. we were kind of the first to go through this process. First third party to file an IPR, first party to get instituted. We have killed patents owned by NPEs. Some of the legal stuff that, if there's any attorneys on the phone, real party and interest is a big deal that we have navigated without any problems, partly because of the strict nature in which we run the company and the way we do it. And I think for those of you who have had any experience with NPEs, we're quite proud of the fact that we have challenged and will continue to challenge the biggest NPEs out there. So companies like Marathon, Intellectual Ventures, IPNav, Empire IP, Acacia. These are entities which are filing lots and lots of litigations, own big portfolios, and I think we're the only entity out there trying to bring that kind of activity in check. So I'm going to maybe skip over this slide a little bit. I mean, there's a lot of advantages to what we do. We're definitely an offensive strategy. And obviously we have members who get to participate. I think the other thing here is that we're extremely cost effective. Because we are not trying to buy licenses at the most expensive point in litigation, we're able to challenge patents and do work on behalf of members and our zones in a way that's extremely cost effective. So for large companies, membership runs up to almost 500,000 and goes all the way down to the lowest membership fee of 35,000. Note that if you're a company that makes under 20 million in revenue, you get to participate in Unified for free. So that's something that we think is really advantageous as a partnership between big and small companies. Really, I think most people want to know what the disadvantages are to us over other solutions, and I think the big thing is that members don't get to control our activities, and so a lot of people would love to control us and tell us what to do. Unfortunately, we wouldn't be able to do the work that we do if they did control us. So that's probably one of the big disadvantages of us. As I had mentioned before, we do have a free solution for membership in Unified. It's called Pledge, and you get to participate for free. You get the ability to leverage the participation of a bunch of bigger companies. So we have both big and small companies that are participating. Big companies essentially provide us revenue to pay our bills, and small companies really provide us with data and long-term risk reduction. And so you get the benefit of participating along with big companies to protect technology areas that you care about. I'm going to jump ahead here. So as a free pledge member, you get lots of other great stuff. You get the same licenses that we get on behalf of big companies. We treat all members kind of the same within a zone. So you get the same licenses that everyone else gets. We hope to obviously save money and reduce risk. Help you deal with your patent issues so that you can make yourself more marketable in the event that you're trying to raise capital. And we also give you small companies rights to the same type of patent data that we give everyone else. So portfolios and landscape reports that we use to monitor our technology areas, we make those reports available to everyone, including our free members. The only thing we get from small companies in exchange is that we want to make sure that you don't sell your patents to a patent troll without telling us first. If you do want to sell to a patent troll, you still can. What we want is an opportunity to get notice of it before you do so. And that allows us to make sure that our members, if they choose, or if we choose to compete and just say, hey, we'd rather bid and buy that patent rather than let it go to the hands of an NPE. So it's a preventive measure on our end to try to get data in advance of patents slipping from the hands of small companies into the hands of patent trolls, and then ultimately becoming a problem for our entire zone. So that's what we ask from our small members. That's the thing that we get in exchange for their free membership.
Hey, Kevin.
Yeah.
One question that I had, you mentioned that the pledged membership is free for any company that has less than 25 million in revenue. Are there any other criteria? Do they have to be active in one of the deterrence zones that you've set up, or are there any other criteria that might be used as it relates to the pledge memberships?
No, I mean, so we have companies who have, small companies who have joined us that just simply like what we do. NPEs, and they participate for that reason alone. Others, yeah, they actually do fall, into the technology areas that we are working in, cloud storage being one, where, yeah, I mean, lots of companies are users of cloud storage, even if it's not necessarily their primary business. And so we have companies that join. The only criteria for free membership is that you make less than 20 million in revenue. And then, just you sign the agreement, and then you just, it's very hands off. We don't ask much. We don't get, in your business, but we're available for you to reach out to. If you've got IP questions and you want to find out, hey, I got this demand letter, what do I do? We're here to help. So the only criteria is that you make under 20 million revenue and you sign up to the pledge agreement, agreeing that you'll tell us before you sell your patent to a patent troll.
Okay.
And that's it.
Great. That's really powerful for startup companies and the smaller companies. So
I'll end here with just a little summary, little case study on our cloud storage zone, and then we'll just kind of show some of the results we've had, and then I'll I think I've run for 30 minutes, so then we can turn it over to Q&A or let it run its course. So we started up the cloud storage zone back in 2013. I think we have almost 30 members in, or even more than that actually, in cloud storage. I might need to update this, but like I said, we are monitoring thousands and thousands of patents, patents that we find that are in cloud storage. We look to see who owns them. We look to see, if they're owned by an NPE or not, patents that are for sale, who bought and sold them. And then we obviously have notice members. Those are the free members who have provided us with agreements that they won't sell patents to patent trolls without telling us first. So we have hundreds of patents under those agreements as well, which we think provide long-term risk reduction for cloud storage. So the deterrence activities, obviously, once we have found NPEs active in the space, we have done prior art searches, and we have filed post-grant proceedings, which are the challenges to challenge patents. So here are basically the success rate for what we've done, and you can kind of see some of this is we've invalidated patents. You can kind of see owned by Acacia and IPNav and Marathon, patents where we have settled the IPR. You can find in the bottom right. We got pending IPRs over to the left. There's a few IPRs in the top left there where we were not successful in getting instituted, but the pressure that we applied, at least in data speed, we believe brought those litigations to an early conclusion. And so if you just add these up, I mean, in cloud storage, we're quite proud of having basically an 82% or better success rate for basically either saving money bringing litigation to conclusion faster, or in some cases, outright killing patents owned by NPEs. So it's something we think cloud storage has really benefited from. And one of the things that we have done in the cloud storage space is look to see what the litigation is that's taking place in that zone, and see whether or not there has been a reduction in litigation specifically for cloud storage itself. And so this slide here, slide 15, shows according to the litigations we've selected that we believe are in cloud storage. 2012, we started in 2013. 2014, actually, there was a drop after we had killed a couple patents and filed a bunch of IPRs. We think cloud storage actually saw less litigation than everybody else, that every other technology area saw. And so you can kind of see that in the gray. We think that there was about 3 NPEs that didn't bring litigation in 2014. 2015, but there was an overall drop, by the way. You can kind of see it from 2013 to 2014 across the board. Every litigation, all litigation basically dropped from 2013 to 2014. 2015, litigation rose, but again, we did not see 2015 litigation rise quite as much as in cloud storage as we saw it rise everywhere else. And so the gray kind of shows litigation that would have been expected, but for some reason didn't happen. And so proving a negative is extremely hard. I wouldn't, I'm not claiming that this is all us, or that it's not possible, if there's some other explanation for it, or that it's a complete fluke. But one thing that we are proud of is we're the only entity out there actually trying to do this very thing, and we do think it's working. And we know that it is, we do have some data showing that we know that it actually does work. And so we have had NPEs come to us in advance of suing in the cloud storage space, and they have said to us, we would rather license and participate with you in advance, get basically secure license rights for you, your big members, your small members. In an agreement, you then leave us alone, and we can go on our merry way. And so we have done deals like that so that our members are protected from those litigations, and that we think is concrete evidence that we are that we are actually deterring litigation from happening in our zones. So it's interesting, and we think that's a big win for us. I'm going to skip over this, but at least you guys can see that when we get involved and file IPRs, cases settle more quickly than cases that are involving litigation across the board. So when operating companies file their own IPRs, litigations often do settle. Actually, most IPRs and most litigations do settle. When we take action, because we don't pay NPEs anything, we think that there's an increased likelihood of getting cases settled more quickly. There's some data that we get involved in, but I think that's basically where I would bring today's conversation to a close, and maybe turn it over for Q&A if anyone has it, and see if anyone's got questions, or otherwise maybe bring the presentation to a close.
Sure. Thanks, Kevin. If anyone has any questions, you can email them in to info@openinventionnetwork.com, or post them on Google Plus on the events page, or via the Q&A module, which we have activated. And yeah, I was just going to ask you, Kevin, how they should contact Unified Patents if anyone's interested. It looks like on that last slide you have the contact information, info@unifiedpatents.com, and the phone number.
Yeah, I mean, if anyone's interested in in participation. I mean, you can obviously reach out to us. You can even reach out to me personally. Contact information, I believe, is on the web page. If you're a small company, actually, you can even sign up without ever even having to talk to us.
Oh,
a way to do it just through the web page. Then you can get the agreement by following the links that refer to the pledge membership category. So.
okay.
Ed, this is Keith.
Hey.
Kevin, I just wanted to reinforce to our community that the uniqueness of the solution of the pledge program is something that I encourage everyone to consider that qualifies. I think it represents a very interesting area, and it's so accommodative of based on where the technology of Linux and open source is migrating, and the technology zones that Unified is focusing on. There's a lot of congruence there, and so I would expect that that over the next year or so, more of our community would recognize the natural opportunity for complementarity by participating in the Unified Pledge program at the very least, and the larger program, the full member, the traditional membership programs. So I would encourage those of you who were not aware before this presentation, I'd encourage you to follow up with Kevin and the team at Unified.
Thanks, Keith. I appreciate it, and yeah, we've been talking for a long time, so we'd love to do more for the OIN community and help out any way we can.
Great.
Well, Kevin, thanks again for your time and for the presentation. We have not had any additional questions, so I think with that we can end the presentation.
Thanks, everyone.
All right. Thank you. Appreciate it.
Thanks, Keith.
Bye.
Take care.